All right, good afternoon, everyone. I'm Angela Nwachi-Willig. I'm Dean of Boston University School of Law and the Ryan Roth Gallo and Ernest J. Gallo Professor of Law, the nation's. Thank you, Ron. The nation's first endowed professorship in critical race theory. On behalf of the entire BU Law community, I'm delighted to welcome you to this installment of the Barbara Jordan Speaker Series on race, law, and inequality. So as many of you know, throughout my career, I have focused much of my research on scholarship related to race, law, and inequality. And after the murder of George Floyd at the hands of former Minneapolis police officer Derek Chauvin in May 2020, our community at BU Law dug deeper into its work of examining racism, conscious and non-conscious, individualized and structural, and looking at the impact of racism on our institution and the people within it. As part of this effort, we sought opportunities for us to more deeply and routinely engage in meaningful dialogue about intersections between race, racism, and the law. And although it's always been important to understand the relationship between race and the law, in particular law's role in creating and facilitating racism, the renewed calls for justice during the summer of 2020 made it all the more important for us to offer our students a broader education, including these lectures, a broader education that exposes them to our country's full history and law's complex role in creating, defining, and facilitating racial inequality. One outcome of these conversations was the establishment of the new Barbara Jordan Speaker Series in honor of our distinguished alumna from the class of 1959, the very first African-American woman elected to Congress from the Deep South. And the series is now endured in perpetuity thanks to a generous gift from Gary Tischler, a graduate from our class of 1987. I'm sincerely grateful to Gary for his generous support of the law school in a wide variety of ways, and for stepping up in particular to fund this series so that future generations of BU Law students and alumni may also hear from leading scholars on issues of race, law, and inequality. For the past 2 years, all of the events in this series have been hosted at the law school or during the height of the pandemic virtually via Zoom. This year, in celebration of our 150th anniversary, we wanted to extend the reach of these important conversations to alumni and friends around the country, bringing the series to New York, Washington, DC, California, and now back to Boston. I'm grateful to everyone who made those events a success, and I want to thank you for joining us here today. It is now my pleasure to introduce today's speaker, Nico Bowie. Professor Bowie is the Louis D. Brandeis Professor of Law at Harvard Law School. He's a historian who teaches courses in federal constitutional law, state constitutional law, and local government law. His research focuses on critical legal histories of democracy in the United States, and his articles have appeared in the Harvard Law Review, the Law and History Review, the Stanford Law Review, the Virginia Law Review, and the Yale Law Journal. He's also written essays for the New York Times, the Washington Post, Slate, and many other publications. In addition to teaching and writing, he litigates criminal and civil appeals, if that was not enough. He's on the boards of the ACLU of Massachusetts, Lawyers for Civil Rights, Mass Vote, and the People's Parity Project. Professor Bowie earned a BA in history from Yale University and both a JD and PhD in history from Harvard University. He clerked for Judge Jeffrey Sutton of the U.S. Court of Appeals for the Sixth Circuit and Justice Sonia Sotomayor of the U.S. Supreme Court. So now it's my pleasure, great pleasure, to welcome Professor Bowie.
Thank you, and thank you so much, Dean Nwachi-Willig, for the kind introduction. It's really an honor to be here to speak with you all in a speaker series named after Barbara Jordan, who is a role model for me for some time. And I'd like to frame the conversation today around one of her most famous speeches that she gave shortly after joining Congress when she participated in the impeachment of Richard Nixon. And so the following remarks are My attempt to organize some of the thoughts I've been thinking about of how to reconcile some aspects of the Constitution, in particular, the way in which it entrenches the law beyond change with another commitment to democracy and democratic equality, the ability of all of us to equally participate in changing what our law means. So Barbara Jordan was elected to Congress in 1972 as not just the first Black woman elected to Congress from the Deep South, but the first Black person elected to Congress from the Deep South since Reconstruction. And she arrived in time for the impeachment of President Nixon and famously declared, "My faith in the Constitution is whole, it is complete, and it is total." These are stirring words. They're also similar to the words that many of the people in this room have recited when they took the oath to become a practicing lawyer, or that law students will take after completing the bar. I solemnly swear that I will support the Constitution of the United States. But what's most interesting to me about Barbara Jordan's words is that they come immediately after recognizing that the Constitution was originally written to exclude someone like her. The Constitution begins with the phrase, "We the people," Jordan said, calling this a very eloquent beginning. But when that document was completed on the 17th of September in 1787, I, Barbara Jordan, was not included in that "We the people." I felt somehow for many years that George Washington and Alexander Hamilton just left me out by mistake. Jordan said it was only through the process of changing that Constitution, through amendment and reinterpretation, that someone like her could be included in the phrase "We the people." Jordan's speech, I think, reveals an important contradiction that all of us must address as American lawyers. On one hand, the Constitution, the most fundamental document in US law, is premised on a government of we the people, a government of consent, of what President Abraham Lincoln famously referred to as a government of the people, by the people, for the people. But on the other hand, none of us was included in the phrase "we the people" when the Constitution was completed in 1787. And this is true not only for those of us who, had we been alive in 1787, would not have been able to participate by virtue of being people of color or women or not owning real estate. It's also just literally true. None of us were alive in 1787. The people who wrote the Constitution all died 2 centuries ago. The oath we must take if we want to practice law is not an oath to the Constitution we wish existed, or the Constitution that we, our present generation, would write if given a blank slate. It's an oath to the Constitution as was drafted by people who are no longer with us, that we did not vote upon, and that sanctioned reprehensible conduct, and that continues to include flaws. So the question that I'd like to talk with you about today is, why do we take this oath? Why do any of us follow Barbara Jordan in declaring a whole, complete, and total faith in the Constitution? And when you take that oath as lawyers to support the Constitution, what explains why the Constitution has any legitimate claim on your loyalty? So I took this oath in 2015. I did it without reservation, yet I find it puzzling. I did not choose any of the words in the Constitution. I was alive for one amendment of the Constitution that I was too young to vote upon. But since I've become a lawyer, there has been no formal or even informal way for me to participate in deciding what should that Constitution mean. So one possible answer for why take the oath, why the Constitution demands our loyalty, is that there's something really important about having a stable source of government, regardless of the content of that stable source. That even if you or I were to change any of the terms of the document, those flaws are minor compared to the importance of having an intergenerational source of knowing where the laws come from, of what Congress or the states are allowed to do. And more importantly, if any of us actually want to work as lawyers, or in the case of Barbara Jordan, want to serve in Congress, it's an oath we have to take. It's forced upon us to the extent that we want to practice this profession. But I think that stability is not a great way of justifying what the Constitution says. It concedes too much. It's an argument that we are all, in effect, forced to take this oath in order to do our jobs. For a government premised on consent, a government of the people, saying, I take the oath because otherwise bad things would happen to me, hardly seems like a robust definition of consent. And around the world, lots of stable governments have included horrific legislation, horrific terms, yet could still be stable. So I don't think it makes sense to defend the United States Constitution and its stirring opening, we the people, as justifiable simply because it is stable. What makes it legitimate has to, I think, to be consistent with the claim that we are consenting to its terms. So a second answer to why take the oath, why declare one's faith in the Constitution, is that it's full of just terms. It's full of good terms. It's just a good document. And that if given the opportunity, if given a blank slate, a document that we would repeat word for word. But I think Barbara Jordan's own family history complicates this answer quite a bit. When Jordan's grandfather, Edward Patton, was born in Texas in 1859, the Constitution permitted the enslavement and racialized terror of 4 million people. Much of the slave economy was built on land dispossessed by Native Americans whose individual and tribal identities were explicitly excluded from the Constitution's term. Even in northern states, the Fugitive Slave Clause permitted white lawyers to literally kidnap Black people, while the Due Process Clause excused a system in which Black people could defend their freedom only in front of commissioners who would get paid more if they found them to be slaves. Perhaps none of these outcomes were required by the Constitution, but they were certainly constructed by people who, like lawyers today, took oaths to support the Constitution's terms. Of course, the Constitution of Barbara Jordan's day looked very different from the Constitution of 1859. When Jordan's grandfather was a baby, Texas seceded from the Union on the ground that northern states were violating the Constitution's Fugitive Slave Clause, a provision that Texas lawmakers said was designed by its framers to perpetuate amity between the members of the Confederacy and to secure the rights of the slaveholding states and their domestic institutions, a provision founded in justice and wisdom. After Texas lost a war to preserve its interpretation of the Constitution, Congress forced Texas and other southern states to abolish slavery, enfranchise Black men, and ratify new constitutional amendments reflecting a new multiracial order. The 15th Amendment in particular prohibited states like Texas from denying Black men the right to vote. But even this amended Constitution permitted grave injustices. The Supreme Court interpreted the 15th Amendment so narrowly that the court repeatedly struck down the first Federal Voting Rights Act on the ground that the framers of the Constitution did not intend for Congress to protect people from vigilantes. When Black litigants asked the court to do something on its own to stop the massive waves of disenfranchisement that followed these decisions, the court responded that the Constitution gave more protection to sovereign immunity than to the franchise, leaving the court with no power to intervene when, quote, the great mass of the white population intends to keep the Blacks from voting. Jordan's grandfather saw firsthand how the Constitution's protection of states' rights, the Senate, and white supremacy allowed white legislators to get away with violently establishing a totalitarian one-party system. Patton was one of the last Black politicians to serve in the Texas legislature when he was elected in 1892, before Texas and neighboring states used force, legal trickery, and violence to disenfranchise the Black population. The number of registered Black voters dropped from nearly 1 million in 1890 to only a couple thousand by 1910. As the senator from South Carolina, Pitchfork Ben Tillman, proclaimed on the floor of the United States Senate, "We have scratched our heads to find out how we could eliminate every last one of them. We stuffed ballot boxes, we shot them, we are not ashamed of it." The Texas legislature would remain without a single Black member until 1967, when Barbara Jordan successfully ran for the Texas State Senate. And perhaps her story is a lesson that things will always work out in the end, that the Constitution may include some bad terms, but overall the good ones will prevail. But I think it doesn't seem all that persuasive given the world we live in today. A principal reason why Barbara Jordan was elected to Congress and to the Texas State Senate was because of laws like the Voting Rights Act. Congress's attempt to enforce the 15th Amendment's terms, despite prevailing interpretations that treated it as inconsequential, given the way in which the South disenfranchised Black people. The Voting Rights Act of 1965 was Congress's attempt to enforce appropriate legislation, to use the language of the 15th Amendment. And as recently as 2006, Congress nearly unanimously reauthorized the Voting Rights Act on the ground that its terms still remained appropriate. But in 2013, 5 justices of the Supreme Court declared that they now believe that same provision of the Voting Rights Act was no longer appropriate. And even though they suddenly disagreed with their colleagues on the bench and in Congress and in the White House, the 5 justices announced that no one could now enforce the provision because it trampled on the Constitution's recognition of the equal sovereignty of the states. And so I could, of course, produce plenty of other examples of flaws in the United States Constitution. The internment of Japanese Americans, the detention of immigrant children, the police-involved murders of Black men and women, the mass shootings in our schools, and the undeclared wars and bombings around the world are all conducted or permitted in our Constitution's name. Perhaps you think these are all appropriate, but to use the vocabulary of the law professor Mike Seidman, if these are parts of the Constitution you dislike, what it can explain why you owe any obedience to them? And so that leaves a third possible answer for willingly taking an oath to support the Constitution. Not that you find all of its terms good and just, not that stability matters above all, but because it recognized a government of we the people, a democratic government, a government in which we all can participate in determining what is our fundamental law, a democracy. If a community of political equals democratically determines what the law should be, that can make the law legitimate, even if some of us would disagree with its terms. For political minorities among us to reject the will of the majority and say that our views should prevail despite yours, in some ways it suggests that our own opinions are more valuable than anyone else's. And so perhaps Barbara Jordan is right, that even though she was originally excluded from the Constitution, the Constitution's amendments and reinterpretations over the years have turned it into truly a government of, by, and for the people. But this justification, which I am partial to, runs into the 2 problems that I started with. First, the people who drafted and ratified the Constitution were hardly Democrats. Despite beginning the Constitution with the phrase, "we the people," many of them strongly opposed democracy. The document was only written and voted upon by about 55 people. At the ratification process over the next 18 months, only about 2,000 men participated. Most of the people alive who were affected by the Constitution's terms had no say in what it would read. But even if the Constitution were the most democratic document ever provided, if everyone who had been alive in 1787 had participated in determining what it would say, there's still a problem in that it is one of the most difficult to amend constitutions in the world. So even if it had been unanimous in the past, today, We can change it only by constructing supermajorities, not just supermajorities among the American people, but supermajorities among the House of Representatives, supermajorities among the US Senate, and then majorities among the House and Senate of 3/4 of the state legislature. No other democratic constitution in the world has that rigorous a procedure merely for changing what one of its words entails. It's the only one that requires anything like it. And so to see how a difficult to amend constitution raises a real problem with a government founded on democracy, consider a hypothetical. In 1861, as part of a last-ditch effort to prevent the Civil War, Congress proposed and passed an amendment to the Constitution that would have forever protected slavery. The Corwin Amendment, as it was known, would have been the 13th Amendment had it been ratified. And it said, no amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state. This amendment, thankfully, did not become part of the Constitution. The bombing of Fort Sumter interrupted the ratification process after states like Illinois voted to approve it. But the failed amendment serves as really persuasive evidence of how undemocratic entrenchment can be. Because imagine if the Corwin Amendment had become law. Imagine if the Constitution included terms that it said could not be amended, like this one. Is there really an argument that any democratic society in 2023 would consider itself bound by this text? Text that not only entrenches slavery, but also forever prohibits future generations from abolishing slavery by national law? I think the problem made clear by the Corwin Amendment is a problem shared by all laws that attempt to insulate themselves from being amended by future generations. They amount to what Simon has called an intergenerational power grab. Inalterable laws create hierarchies of inheritance that give generations from the past an asymmetric power to dominate generations in the present. Even if the Corwin Amendment had been adopted by the most democratic procedure imaginable, future generations would still be effectively disenfranchised from amending it. Yet these disenfranchised future generations are precisely the generations targeted by any attempt to entrench the law. The only purpose for entrenchment is to stop future generations from having second guessing the first generation's decision. And this is true not just of the Corwin Amendment, which is not passed, but the rest of the Constitution as well. It's a dominating hierarchy, not just with respect to people who are no longer with us, but for people who support the status quo. With any provision in the Constitution, most of us could think we would rewrite it differently. But to the extent that a handful of us say, no, what exists now is good enough for me, there's nothing that we can do because of rules drafted by that same past generation. Indeed, the authors of the Constitution recognized the problem of entrenchment, the problem of being bound by the amending rules of the past generation. They rejected the Articles of Confederation, the Constitution that existed before the Constitution, which said it could be amended only by the unanimous approval of 13 states. James Madison and other advocates of the US Constitution ignored this restrictive amendment procedure, recognizing that, quote, the people were in fact the fountain of all power, and by resorting to them, all difficulties were got over. They could alter constitutions as they pleased. And so in contrast with the Articles of Confederation's extremely restrictive amendment procedure, Madison proposed a far more liberal amendment procedure, which today is the most restrictive amendment procedure in the world. There is in fact a rich tradition in US history of constitutionalists opposing entrenchment on the grounds that is incompatible with either democratic equality or the equality of our generation to make our own law on the same terms as previous generations could make theirs. Thomas Paine, when he wrote Common Sense in the lead up to the American Revolution, made precisely this argument against the hierarchies formed by entrenchment. Under the then prevailing view of the British monarchy, the reason why someone like George III had power to rule was not because he was the smartest person alive at the time, or because anyone had decided in his lifetime that he should be king, but because of decisions made by past generations, decisions that his family would descend with the crown. For Paine, this was in the, quote, nature of oppression to permanently subject the present generation to rule by the foolish, the wicked, and the improper, merely because something once seemed like a good idea. He wrote, "There never did, there never will, and there never can exist a parliament or any description of men, or any generation of men in any country possessed of the right or the power of binding and controlling posterity to the end of time. The argument that we must be bound by our past generations' decisions is a complaint incompatible with a free people. Man has no property in man, neither has any generation a property in the generations which are to follow. Every age and generation must be as free to act for itself in all cases as the ages and generations which preceded it. The vanity and presumption of governing beyond the grave is the most ridiculous and insolent of all tyrannies." Paine was writing in conversation with another political philosopher, Edmund Burke, who famously defended the idea that one generation could bind the next. The very idea of a state to Burke was a community whose fixed compact had been originally made not only between those who are living, but between those who are living, those who are dead, and those who are to be born. If the community in one generation lacks the power to bind successive generations, then the only law that could exist is the will of a prevailing force. But Paine responded to this line of reasoning, anticipating Barbara Jordan, that a better way of understanding law is not as one generation's attempt to formally entrench its law, but as a rule that is always subject to amendment by the future. A law not repealed continues in force, not because it cannot be repealed, but because it is not repealed, and the non-repealing passes for consent, Paine wrote. All laws that the present generation does not repeal derives their force from the consent of the living. Paine's ideas were influenced in part by conversations he had with Thomas Jefferson, who made a similar line of reasoning in recognizing that entrenchment undermines political equality by allowing people at the top of a social hierarchy in one generation to pass along their wealth, power, and privileged social status to their children. Like Paine, Jefferson argued that no society can make a perpetual constitution or even a perpetual law. The earth belongs always to the living generation. Jefferson wrote these words in a letter, a famous letter to James Madison shortly after he read the US Constitution, which he complained was far too difficult to amend. Jefferson considered it a, quote, act of force and not of right to subject later generations to his own generation's amendment procedures. Where Madison thought Article 5's amendment procedure was enough for a future generation to change what his generation had done, Jefferson argued that the Constitution should expire after 19 years, allowing the next generation the same blank slate that his had to determine its own fundamental law. The authors of most state constitutions took Jefferson's advice. They typically included provisions that automatically called constitutional conventions every 20 years, or otherwise recognized that if constitutional revision is too difficult, constitutionalism can overwhelm democracy. Only a handful of states still use their 18th century constitutions. Massachusetts is one of them. But most, like New York, have adopted multiple constitutions to take advantage of ideas that were not prominent in the 1780s, like workers' compensation and the 8-hour workday. During New Jersey's Constitutional Convention in 1947, organizers from the CIO argued that they would be happy with the new constitution if the only change made to it was that it was easy to amend. And all this explains why an inalterable provision like the Corwin Amendment would have been profoundly anti-democratic. For the American people in 1861 to attempt to permanently bind their successors would have been a literal act of enslavement. And the same intuition carries over to the rest of Article 5, which makes it incredibly difficult for even supermajorities of the American people to clarify whether and how we want to be bound by the document's terms. But unfortunately, the authors of the US Constitution did not follow Jefferson's logic, and it contains the most difficult to amend procedures of any national constitution in the world. You and I have never had any opportunity to be asked our considered will in our constitutional system, including whether we wish to be governed under the existing Constitution. Instead, we appear doomed to live our lives under inherited protections of social hierarchy, like the Senate's lack of proportional representation or the Supreme Court's narrow interpretation of the 15th Amendment. Barbara Jordan, for her part, appears to have recognized this problem. She said it was only because the Constitution could be changed through amendment and reinterpretation that someone like her could be included in the phrase, "we the people." And I think there is profound truth in that recognition, one embraced by later democratic theorists like Roberto Unger, who called democracy the permanent creation of the new. For any constitution, good or bad, to be compatible with democracy, to have a claim on our consent and to be legitimate in a democratic society, it must resist entrenchment and embrace the ability to be changed. So how can we, the people today, make our own constitution more consistent with democratic equality and resist the forms of entrenchment baked into it? Jordan's speech points to two possibilities: amendment and reinterpretation. And in addition to those two possibilities, I'd offer a third: organizing. So the first possibility for eliminating the danger of formal entrenchment in a democracy is just to formally amend the Constitution to make it easier to amend. And I don't mean that we need to bang our heads into a wall saying that Article 5 is never going to be overcome, and so we are destined to just live our lives under its current terms. Rather, just as the authors of the Constitution itself ignored the impossible amendment procedures of the Articles of Confederation, our current generation must be able to make our Constitution democratic through methods other than following the word and the spirit of Article 5, the most intractable procedure in the world. Indeed, some of the most just elements of the current US Constitution, including the 13th, 14th, and 15th Amendments, would likely not have been ratified had the people alive in the 1860s gone through the specific procedures contemplated by Article 5. Consider the 14th Amendment. In 1866, the United States included 37 states, of which 11 had seceded during the Civil War. This meant that ratification depended on 28 states. But with one exception, Tennessee, every state in the former Confederacy resisted ratifying the new amendment, dooming it to fail. So Congress responded in March 1867 by passing the Reconstruction Acts, which required each of the remaining rebel states to ratify the 14th Amendment before the state was entitled to representation in Congress. But before any of these states even ratified the 14th Amendment, New Jersey and Ohio attempted to withdraw their ratifications. Congress effectively took this situation and interpreted it in the best light possible, not in terms of what the authors of Article 5 would have wanted, but in terms of what they thought multiracial democracy demanded. They interpreted New Jersey and Ohio's attempt to return their ratification as null and void, and they authorized the ratification of the 14th Amendment by the South under the terms of the Reconstruction Act, terms that prohibited these states from sending members of Congress to DC as legitimate. For the rest of the 19th century, lawyers from Southern states, including the US Solicitor General at one point, at various times argued that the 14th Amendment was something of more than doubtful validity, given how the 14th Amendment was ratified. But I think a better response to this story is that the only thing of doubtful validity is the Article 5 amendment process. It also shows how amendment outside of Article 5 may be the only plausible method of making the Constitution more democratic. What might amendment outside of Article 5 look like today? A recent student note in the Harvard Law Review, what I think is probably the most important student note written in the Harvard Law Review in the past decade, observed that simple majorities in Congress have the formal power to admit dozens of new states, all of which could supply enough senators, representatives, and state legislators to enact any law or constitutional amendment under the procedures of Article 5. In particular, a sufficiently motivated Congress could assemble enough votes to admit each of Washington, D.C.'s neighborhoods as a new state, and together ratify 4 new amendments. 1, a transfer of the Senate's power to a body that represents citizens equally. 2, an expansion of the House so that all citizens are represented in equal-sized districts. 3, a replacement of the Electoral College with a popular vote. And 4, a modification of the Constitution's amendment process that would ensure future amendments are ratified by states representing most Americans. At that point, Congress could return the states back to the District of Columbia. The essay author recognized that this proposal might sound radical, but warned it is no more radical than a nominally democratic system of government that gives citizens widely disproportionate voting power depending on where they live. The essay concludes, the people should not tolerate a system that is manifestly unfair. They should instead fight fire with fire and use the unfair procedures of the Constitution to create a better system. But formal amendments are not the only way of changing the Constitution to reduce the problems of its formal entrenchment. A second path forward identified by Jordan's speech is that the Constitution can also be made more democratic through informal interpretation. Today, the Constitution is routinely updated by interpretation. In 2012, the Constitution authorized Congress to enact and enforce the Voting Rights Act's pre-clearance regime, ensuring that no new voting law would make it more difficult for political minorities to participate in governance. But in 2013, the Constitution prohibited Congress from enforcing this regime. The thing that changed was not the text of the Constitution. There was no new 29th Amendment that banned the Voting Rights Act. Instead, the only thing that changed was how the Constitution had been interpreted by the Supreme Court. Similar decisions over the years illustrate the power of reinterpretation. But a democratic commitment to amending the Constitution informally through interpretation does not mean that the Supreme Court is the appropriate institution to offer the final word. To the contrary, just as democracy demands that the Constitution be easier to amend, democratic equality also demands that the final say regarding the Constitution's meaning must belong to contemporary institutions that most accord with democratic equality. My colleague at HLS, Daphne Renan, and I are writing a book called Supremacy: How Rule by the Court Replaced Government by the People, which is a history of judicial supremacy, the idea that the Supreme Court's interpretation of the Constitution should be supreme, with alternative forms of constitutionalism, including political constitutionalism, the idea that we, the people, can interpret and enforce our interpretation of the Constitution using political processes through legislation. And in his inaugural address in 1861, President Abraham Lincoln offered perhaps the most famous defense of this idea for why Congress and not the Supreme Court should have the final word on what the Constitution requires. The court had just held in its infamous Dred Scott decision that Black people could never become citizens and that Congress had no power to abolish slavery in the territories. And Lincoln responded, "The candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Lincoln thought that a self-governing people should have the power to determine what their fundamental law meant. Lincoln's argument was not that the Constitution should not be enforced, but rather that Congress and political institutions were the best to enforce it. Most of the Constitution's limits are vague. The 15th Amendment permits Congress to enact appropriate legislation, and the Fifth Amendment prohibits Congress from violating the due process of law. But for as long as these limits have existed, there have been passionate disagreements about what they require. Relative to the Supreme Court, Congress offers a relatively democratic method for resolving these disputes. If people or state governments disagree about a federal law's constitutionality, they can campaign to repeal the law. By contrast, when the Supreme Court decides not to enforce a federal law, or when it offers its own reinterpretation of the Constitution's meaning, the justices in the majority effectively declare that their view is superior to everyone else's. Even if the president, 500 members of Congress, and majorities of state legislators interpreted the Constitution to mean one thing, if 5 justices disagree, then the law cannot be enforced. And this was the scenario in 2015 or 2013, when 5 members of the court held that the key provision of the Voting Rights Act was no longer appropriate. Indeed, I find it hard to explain why in a democracy, the constitutional interpretations of 5 justices should be superior to the interpretation of the elected officials who appointed and confirmed them. No democratic procedure requires the justices to think of themselves as political equals with the people who disagree with them. And while later generations of the court can always overturn their decisions with a simple vote of 5, the rest of us have the formal power to overrule those decisions only by going through the most difficult to amend constitutional procedure in the world. Nor is there any historical reason to think that there's something intrinsically correct about the court's interpretations relative to the political branches. No expertise on the planet can determine whether Congress's 1875 ban on racial discrimination, its 1965 expansion of voting rights, or its 2020 expansion of health insurance is appropriate or providing for the general welfare. Resolving those questions require the same trade-offs among competing principles that a democracy makes when it decides to enact any law. Our democracy suffers when an unelected group of lawyers takes away our ability to govern ourselves. And this isn't to say that Congress hasn't adopted horrific laws over the past 250 years, but there are few examples of the court intervening in a timely fashion to overrule them. The court was silent at best when Congress violently captured fugitives from slavery, dispossessed Native Americans, excluded Chinese immigrants, persecuted political dissidents, and withheld civil rights from US citizens in territories. Efforts to remedy these injustices have been achieved not by courts, but by expanding our democracy. Which is why I think both of these forms of reinterpretation of changing the Constitution have to be put in conversation with popular mass organizing. Frederick Douglass put it best in the 1850s when he explained that the only group we the people can rely upon to ensure that the Constitution is interpreted to perfect our values is we the people. As he put it during a time when both Congress and the Supreme Court were interpreting the Constitution to sanction slavery, we are not to be saved by the captain at this time, but by the crew. We are not to be saved by Abraham Lincoln, but by that power behind the throne, greater than the throne itself. The power he was referring to was public opinion, mass sentiment that he and other abolitionists could tap into through activism, meeting, books, political campaigns, petitions, and the day-to-day work of organizing. In the words of the Political Anti-Slavery Convention in August 1860, our only hope of success is in translating our sentiments into statutes, and coining out words into deeds. Other groups throughout history have emphasized the importance of reimagining and reinterpreting the Constitution through statutes demanded by an organized public. When James Madison and Thomas Jefferson opposed the constitutionality of the Alien and Sedition Acts in the 1790s, they enforced their interpretation not by seeking new amendments or litigating, but by forming a political party, running for office, and enacting contrary legislation. When the industrial workers of a world a century later demanded an end to constitutional interpretations that allowed the government to suppress their organizing, they put their faith in their own organizations. Leaders of the IWW famously opposed labor contracts on the theory that the best legal text was nothing more than words on paper, words that can never enforce themselves, even as they lull us into thinking that nothing about them will change. For the Wobblies, a contract was only as good as the leverage that organized workers could bring to the bargaining table, leverage exercised in the form of strikes, boycotts, and other forms of disruptive power. I think they were right. To reconcile one's faith in democracy with faith in a fundamental political structure like the US Constitution, you need to have a theory for how we, the people, can change constitutional law to make it work for us today. Entrenchment, whether in the form of a difficult to amend constitution or a constitution that can be interpreted only through unaccountable courts, is just another way of perpetuating domination. But the law is not text alone. Law is the willingness of all of us to accept the justice of a particular set of rules or to deny the justice of those rules. And to achieve the justice that we, the people, demand, we cannot rely on compromises of the past, but must enforce and forge our own interpretations into the future. Thank you.
Hi, thank you so much for being here. I wonder how many of the arguments that you make against entrenchment can also be made against democracy. That is it an argument against constitutionalism that you're offering here, or an argument against government as such? And in case anyone doubts it, I ask that as an anarchist. Right? I mean, it's not obvious that people in 2023 have more of a right to tell me what to do than people in 1788. Is it? I mean, is it obvious?
I think that arguments against entrenchment can be broadly applied to any organization. And to the extent that an organization is voluntary, one that we're choosing to be a part of, then absolutely I agree that the ability of that organization to enforce its will upon me would just lead me to leave. But I think that one broad commitment to being as part of a democratic government is accepting that sometimes you win and sometimes you lose, so long as you have the ability to be on one side or the other. That accepting your participation as part of a community does not necessarily entail consensus on all outcomes of that community, but consensus on the rules governing that community and the decisions that it makes over time. And I think that is an important distinction to make between the contemporary lawmaking process, where I don't expect that my views will always prevail, from a form of law that I and our generation today have effectively no ability to change.
John, thanks for your talk. I have two questions. One question has to do with when the Democratic body entrenches their own power. I didn't hear your talk mention that, like when Congress would entrench its own power and then prevent incumbents from infiltrating the democratic process. Maybe you did, and I didn't hear it. And the second has to do with teaching constitutional law today. I'm increasingly frustrated with how the books are structured and teaching from the Supreme Court decisions, et cetera. And I'm wondering if you have thoughts about how to teach constitutional law today to current law students that might open up the conversation beyond judicial supremacy to what you're talking about?
Yeah, so I think that there is always a risk that governments or like Congress will pass bad legislation or legislation to entrench its own power or views. And I resist that entrenchment just as I resist the entrenchment of constitutionalism. But I think that there isn't a lot of evidence that the US Constitution or constitutional enforcement and protection via courts is an effective defense against that form of entrenchment. We live in our current world in which entrenchment, it prevails across the country in all kinds of institutions, given our current structure. I don't think that our current structure has stood in the way of that getting worse, nor do I think that it alone has been enough to provide an avenue for eliminating it. By contrast, every time that our democracy has expanding to include poor people or Black men or women, it hasn't come from, say, a court interpreting a text and concluding, I'm sorry, but the prevailing views are wrong. Please include these people as part of your democracy. They've come from mass organizing of disruptive power, of maintaining leverage outside of formal political structures. And so that's why I have, to the extent that I'm optimistic, it's the optimism of the Wobblies that there is some value to relying on disruptive power and treating that as the main check on exclusion, rather than relying on the text of a particular document. As far as teaching constitutional law, so I think that one important way of approaching the subject, for me at least, has been approaching it historically. So when I teach constitutional law, I tend to teach each of the doctrines over time, not because I want to create a unified story of like, this is the true interpretation of the Contracts Clause or the Commerce Clause, but rather to show how what the Commerce Clause or anything like it means is the consequence of a lot of context and important decisions that are happening at the time that these reinterpretations are being made. And I think that treating doctrine or treating interpretations as something that isn't just what exists today and what will always exist over time, but rather the consequence of real struggle, and that can be changed by us going forward, is just an important way of emerging from a class like that, not being totally disillusioned.
Hello. Excellent lecture, really illuminating and I hope motivating for many. And I look forward to your book. I have a question about how organizing might proceed most effectively. Our form of government has both a fundamental law and an ordinary law, but the fundamental law might not only limit the ordinary law and thus what can be done through organizing, but might actually serve a role in motivating the organizing. So for example, do you envision that organizing will be mainly directed in terms of what justice requires, or do you envision it as being more what the Constitution requires, if we are to honor the promises of the Constitution? In other words, to what extent will the organizing that you envision be constitutional discourse, and to what extent will it be simply democratic or justice discourse?
So I think constitutionalism in its best form provides a political education. It's a commitment to a particular set of values that one can aspire to without necessarily binding us all to those values or the procedure for achieving them. And so I think that over time, movements like the civil rights movement have interpreted the Constitution as a very valuable source of legitimacy and as a way of grounding a particular movement in a broader tradition, saying that this is not an American or different, but rather part of our nation's story and where we should go forward. So I think that role that constitutionalism plays of saying that, this is a country that is founded on the principle of wanting to establish justice is a good one. But I think that in imagining how the Constitution will change going forward, it likely has to come in the form of what do we think that justice today requires? What values do we think that our generation should treat as fundamental? And not necessarily what do we think that the 1787 generation, the capital F, capital G founding generation would have wanted us to do. And so I think as far as particular applications of what this means, right now there is a struggle about, does the Constitution protect reproductive justice? Some people say it does not. Some people say that it does. I don't think that organizing necessarily needs to turn on let's change the Constitution or let's figure out the Constitution's true meaning, but rather it can provide the vocabulary for organizing campaigns to enact something like a Women's Health Protection Act, as well as the legitimacy to say that this is not a, what matters is not the rules as they currently exist, but the rules going forward that our generation wants. And the interpretation of the Constitution that we today think would lead to the most just outcome.
Hi, thanks so much. I was really interested by the student note that you had mentioned about packing related to the amendments. And I'm curious when we think about that level of kind of extra constitutional amendments. So comparing it to what you were saying about the 14th Amendment and the Civil War amendments generally, that strikes me as a period of like pretty singular like disequilibrium, right? Like that was very clearly a point where the traditional rules were not going to apply. And looking backwards, like for me personally, I'm like, okay, that makes sense. I understand that we could go outside of the normal channels to do what had to be done. And I'm curious if you could see a similar argument holding in the present time. And if we were to kind of go down those more dramatic amendment routes, is there a risk of creating such disequilibrium that we lose some of the stability? I know that stability you were saying is not kind of an end all be all, but it is of some value. And to go down those kind of more extreme routes, is there an obligation to say, well, actually, like that is a risk that it creates such disorder that we lose something that was valuable? When people are advocating for that, is there an obligation to say, yes, it's worth taking that risk, even with this potential downside?
Yeah, so I have two responses to this good question, one historical and one prescriptive. So, I love this note. It's called Pack the Union. And one of the things that I find so appealing about it is there's actually just nothing extra constitutional about it. Congress, like the Constitution, reading it just literally, the text gives Congress the power to admit new states. Historically, when members of Congress have sought to enforce their interpretations of the Constitution, one effective vehicle for doing that is admitting new states. Like so many of the political struggles in Congress leading up to the Civil War was how to admit enough new states that our interpretation of the Constitution would prevail over alternatives. And so I think that's a latent issue behind, say, the admission of Washington, D.C. as a single state. But to admit 127 Washington, D.C.s as states, I think, it obviously is an extreme version of this idea, but it's an idea that has been responsible for new interpretations of the Constitution historically. I think prescriptively in thinking, how to justify this, there are lots of what David Posen at Columbia Law School has called veto gates in our Constitution. So in contrast with, say, the British Parliament, which can enact new legislation if the House approves it. Here we not only have these committees and the House of Representatives, but also the Senate filibuster, the presidential veto, judicial review. There are a tremendous number of veto gates. And every time an argument is made to eliminate one of those, say, let's get rid of the filibuster, the response is, but won't the other side do something bad? Like if we eliminate this source of stability, won't that result in worse outcomes than the one we have today? And I think that that's only a tenable argument to the extent that you find the status quo acceptable. You know, the people who are most likely to support the continuation of the filibuster or the continuation of our constitutional order, I would expect are the ones who most benefit from it today. And so I think a response to that kind of argument is to say, no, the status quo is not acceptable. Our democracy is, going into the toilet. We're all about to drown because of a climate crisis. There are too many problems. And one of the reasons for hyperpartisanship and disillusionment is because we do not have a government that can effectively respond to them. Reading the just the letters and arguments and articles written in the 1780s about the Articles of Confederation really just pale in comparison to articles today about the problems of our constitutional order. At the time, people like Madison were complaining like, oh my God, like we don't even have the power to enact a national law that can regulate, trade and ensure that we, abide by treaties. Whereas today, kids are getting killed in schools. Like there are so many issues that it just feels like, there's nothing that can be done. And I think that's just a sign for, we need to change.
Nico, thanks for coming. It's a terrific talk, a really important reminder about democracy, and the work with Daphne Renan is excellent on separation of powers, and I look forward to the book. And I wholeheartedly agree with the idea that we need more states, and why stop with, maybe 1,000 DCs is one thing, but Puerto Rico should be a state, DC should be a state, there should be a North and South California, we should have more justices, but I think the question is, these things are all doable by majorities of Congress and presidential signing. The Constitution isn't the problem, the American people are the problem. I mean, it is astonishing and worth noting that even after Dobbs, there is no public pressure to expand the court. And so one question here is, isn't this a problem of the American people, not the American Constitution? And second, if the problem is the American people, then maybe we need the entrenchment of the rule of law. Trump says it's, the deep state blocked my Muslim ban. I tell my students, search and replace. Every time Trump says deep state, that's the rule of law. But on the flip side, every time you say entrenchment, we might also say the rule of law. If the American people are still the problem, don't we need a rule of law / entrenched constitution of John Hart Ely?
Yeah, so I think that it's hard to disaggregate, sort of the question of what does today's generation want from how does today's generation's views get translated into public policy. So to give an example, the example that I referred to in the talk, the one reason why our elections today are such a mess is because we have not had the Voting Rights Act enforced as intended for the last 10 years. The reason it has not been enforced as intended is because of the Supreme Court's interpretation of the 15th Amendment in contrast with past court and Congress's interpretation. And so to say that today's generation would not want the Voting Rights Act because we have not passed it again, I think is to take for granted the ways in which entrenchment can structure how public opinion is manifested. And so, I think that this was part of the point that Thomas Jefferson was making in response to Madison. It's one thing to ask somebody, what would you change about the existing order? And it's a very different thing to say, here is a blank slate, start over, and what would you include from the present? And I think that in some ways is a better reflection of sort of what would our generation want. So I also hear the point about the rule of law and stability being a really important value, which I don't deny. I am not in favor of sacrifice. I don't treat stability as a problem. I just don't think that it should be the prevailing principle, the one that dominates all others, especially when it's in conflict with other values that I care more about, like political equality. And so do I think that federal laws should be enforced? Yes. But do I think that federal laws should be changeable? Absolutely. And so I think the same about the Constitution, but it's on such a worse scale in terms of how difficult it is to change that I don't think looking at today's polls and asking people, given the structure we have now, are you feeling empowered? Are you feeling like, these are the changes you want, are necessarily an accurate reflection of what we would do if given the choice.
So Nico, thank you very much for your excellent lecture. I have a question from our virtual audience, and you've attracted some major players here. Ryan Roth-Gallo, who's the vice chair of our board of trustees, is listening and had a question for you. Which governments outside the U.S. would you look to as models for us?
One of the funny things about comparative constitutional law is just seeing how unique in some ways U.S. constitutionalism is. So there is actually just no government elsewhere in the world that combines how difficult it is to amend our Constitution with a court that has the supreme power to interpret its terms. And so I think that uniquely creates a situation where the sort of most plausible method for changing constitutional interpretation today is through litigation. And when the door of litigation appears shut, then people who go through a law school where litigation is the primary theory of change feel extremely disillusioned. It's like, what are we doing here? It seems like, how are we going to change law if the only way to change law is through courts? But it's not the only way to structure a government. So the United Kingdom, I think the United Kingdom has lots of flaws, but one thing it does well is that Parliament can change the law. It can change the Constitution by a simple majority of one house. That to the extent that there are problems with how its first past the post system is structured, or other aspects of how the British political system leads to problems, the main issue there is not formal entrenchment, but rather I think it more reflects the views of the political order rather than the views that are filtered through these forms of entrenchment. New Zealand offers a really great alternative in the sense that, like the United States in the early 1990s, it had faced a similar problem of hyper-partisanship and really ineffective national government. New Zealand adopted a series of amendments to its unwritten constitution that adopted proportional representation and methods of incorporating the indigenous community into government that has led to a far more both effective government as well as making people feel more empowered and less likely to kill one another over partisan terms. So I think that we have a lot to learn from other communities. I'm really excited about what has happened in Chile, just as a model of, look, we do not have to live by the current constitution that we have now, that change is possible. And so looking elsewhere, I think, offers a lot of guidance that the people who authored the 1787 Constitution didn't have access to because time has passed since they died.
Hi, first I just want to thank you. It was really wonderful talk and I cannot wait for the book. Really wonderful. I just want to ask you what your views are about violence in organizing. And the reason is, I mean, there is one way to think about how bad the last generation issues have been, which is that we were badly out-organized on voting rights, just terribly out-organized, and they were very organized. Same with the abortion issue, just badly out-organized. And that organization got us, the assault on the Capitol. That was organization. And it's not that it hasn't gotten us anything, but I really, and I'm a believer in organization, but I wonder how your account handles violence.
Yeah, so I think I struggle with violence much in the same way that abolitionists did in the 1850s. And so part of what the book that I'm writing with Daphne Renan goes through is, people who have wanted to enforce different constitutional interpretation than the prevailing order. And so for abolitionists in the 1850s, violence was very much on their minds. Was this slavery going to be abolished by persuasion and mass organizing or through shooting people? And ultimately it was both. The Civil War killed millions of people, which before the 13th Amendment was ratified. And so I don't endorse violence in the abstract as the only way in which we're going to make the world better is by, hurting people. I think that there are too many alternative campaigns that have been successful that have not relied on violence. But of course, I think that violence is behind the scenes in all forms of constitutional interpretation, including, as Robert Cover famously said, the violence that accompanies litigation and enforcing the law through courts. And so from that perspective, violence may not be avoidable, but it can be channeled. And so I don't think that merely because organizing can turn violent in the form of January 6th means that organizing as an engine for improving the world around us should be foregone.